Good afternoon, and thank you again for joining us. I'm Tammy Welty, and I am the Director of Training and Communications at Bradford Barthel. Go ahead and check out your GoToWebinar panel. And in your panel, I'd like for you to please locate the handout section. In the handout section, you'll find a copy of today's PowerPoint presentation. And then I would like for you to locate the questions section, as some of you already have. And just to let me know that you know how to use our questions section, I would like for you to answer this question for me, but without looking at Google. On average, how far do a typist's hands travel in a day? On average, how far do a typist's hands travel in a day? So go ahead and enter that in the questions section. And I'm going to provide some information about Bradford and Barthel, and then I'm going to take a look and see what you guys came up with. So on our website at bradfordbarthel.com, you will find tons of information and value-added services. I want to quickly tell you about 3 of them. Do you need CE credits? I know for a lot of you, they're due in June. On our training page on our website, you will find upcoming webinars you can register for, like today, and over 50 videos that you can watch and earn certificates for CE credits. Do you need a rating string, or maybe have a complicated PD rating that you need assistance with? I highly recommend that you try out our AMA analysis and rating department. And finally, I think our attorneys write amazing blog articles discussing all things workers' compensation. And we average a couple of new articles a week, with 2 being released this week alone. So go check out our blog when you have a moment. We are recording today's webinar, and certificates will be sent to you within 24 hours. I typically send them out the same day. Okay, let's look at those answers. There's a lot of them. I've got 2.5 miles, 10 miles. I'm trying to see if I have a correct answer in here. 500 yards, 60, 50, half mile, not sure, right? I agree, not sure. That's a hard one. Okay, I don't see anybody. 5 miles. I'll give it to you if you're close, but I don't think anybody's close. I think the closest is 19, and that's still quite a few miles. Oh, 15 is the closest. So 15 is the closest right now, but I will go ahead and give you the answer, and the answer is 12.6 miles. I thought that was pretty interesting. So with that, we're going to go into introductions. Tamina, do you want to start us off?
Sure. I can't believe that. 12 miles or 15 miles? That's pretty amazing. I want to know what Jessica is typing, because she says 100 miles traveled. And she's writing the great American novel, I'm sure. But thank you all for participating in that. That was a bit of fun. My name is Tamina Ahmed. I am the managing partner for client relations with Bradford and Barthel. Quite a few of you know me. I've had the pleasure of working with a lot of you over the past 24 years of my service at Bradford and Barthel. The firm is in our 25th year this year, so I want to take this time to acknowledge that and acknowledge your loyalty and support. We couldn't do this without you, and we appreciate all of your involvement in our day-to-day lives, and we hope we make some difference in yours as well. With that, I'm down in Woodland Hills, but travel everywhere, have visited clients all over. That's part of the fun part of my job. I work with some amazing people. Glenn and Hayden actually happen to be in my office. So I have the pleasure of talking to them more often than with some other folks. And I think you guys are in for a good presentation today. So with that, I won't take any more of your time, and I'm going to pass it on to, was it Nick?
Yes.
Okay, there you go.
Hello, everyone. For those of you who don't know me, my name is Nick Ward, and I am out of the San Diego office. I have now been with Bradford and Barthel for 5 years. I've always been in the San Diego office. San Diego, we typically only handle San Diego claims, but with everything being virtual nowadays, we can really handle almost any venue would be fine. Yeah, so I'm also on the COVID team for this. So if you have any questions in regards to a COVID claim, I know they're coming back up, I think, a little bit lately in the last few weeks. You could send that to our COVID team, and one of either myself or a few other of my colleagues will be able to give you an answer on all sorts of questions. We've answered almost every type of question you could have in regards to COVID. So our team is pretty knowledgeable in that regards. A little fun fact about myself is that 4 weeks ago I got married. And so a little something to make you guys jealous is that in a few weeks, we're going to be heading to Italy for 2 weeks. So maybe not a fun fact at the ending, a little jealousy there for you. But yeah, so that's me. So email me anytime if you want or have a question about any case, a question about anything. I'm always available for any questions. Nice to meet you. And yep, that's me.
Thank you, Nick. And Nick is referring to our COVID email, which is covid@bradfordbarthel.com.
Yes.
Go ahead, Scott.
Oh, thank you, Tammy. Hi, everyone. My name is Scott Dodd. I'm an attorney in the Fresno office. So we handle mostly the wards of Fresno and Bakersfield, but in these times of COVID, we cover cases all over the state, it seems. Fun fact about me, my wife and I have been married almost 20 years. We have 2 wonderful boys, 4 and 13 years old, and I'm coming up on this Labor Day will mark my 3rd year at Bradford Barthel. And with that, I thank you so much and look forward to Glenn and Hayden's presentation.
Well, hello, my name is Hayden Beach and I will be one of the presenters today. I work out of the Woodland Hills office. I'm one of the assistant managing attorneys and partner. We handle everything. Glenn and I are working constantly together on all different things. A fun thing about me, I am not having a yard sale, as Tamina had said before we started this. These are a lot of my collections. Most of these are Legos, so I do a lot of the architecture Legos. This is the John Lennon picture, so that's what I do on my very little amount of off time that I have. And now Glenn.
Thank you, Hayden, and it's always great to have you on these presentations. You just do an excellent job with the cases. You guys will hopefully be able to see that. Fun fact about me, well, I love to fish. I usually go out of San Diego and I go tuna fishing. I'm just not good at it. So if you ever need a story about the big one that got away, I have lots of them. But anyway, that's what I like to do on my spare time. And I wanted to thank you guys for actually attending during your lunch hour on your spare time. I hope that this presentation is going to teach you something, at least something about 132A and how good Hayden looks in a suit. And then we'll take it from there. Let's start with 132A itself. So if we can get the slide, we're not going to read this word for word, obviously, but what I thought was interesting is if you go about halfway down, it indicates that there are misdemeanors involved. You guys see that? So this has penal implications, it has civil implications, it has workers' compensation implications. I've always been fascinated by that and how they indicate that you would be guilty of a misdemeanor. It doesn't say you may be guilty of a misdemeanor if you discriminate against an applicant on a workers' comp 132A claim. It is a misdemeanor. We're guilty. So it's good to know that. I haven't seen a criminal prosecution in 132A claims in my 25 years. Maybe somebody else has. I wouldn't want to be the first one. And that's why we're going to talk about it a little bit today. I do think it's.
I think it would certainly have to be egregious to get to that level.
It would, obviously, because I don't know if they have the time to go after, everybody that may have or may have not discriminated based on employment. So we know what a 132A does. It discriminates against an applicant for filing a claim, or if you believe that they are going to file a claim. And I always thought that was interesting too, because I recently had a case, and the employer obviously, and they would have to know that the applicant's going to actually file a claim, but should have known comes into play here. So what I have is a case where a tractor driver is going too fast for a right-hand turn. He's going about 20 miles an hour. He's supposed to be going 8 to 10, and the tractor flips over. And the applicant he's hurt, he's scraped, he's got bruises. The supervisor and the mechanics come out and they get the tractor back on its wheels, and they tell the applicant immediately before you do anything, take this back to the shop and come into the office. So the applicant gets back on his tractor and he drives it into the mechanic shop. As he's in the mechanic shop, the mechanics are asking him, how you doing? Is everything okay? We saw what happened. Yeah, everything's okay. He says, okay, you want to go to lunch with us? And the applicant says, sure. So as the applicant is walking out to lunch, the supervisor opens the door and says, wait, I need to talk to you. So the applicant goes into the office, at which point he's terminated for being a bad tractor driver. At which point the applicant says, but I need to see a doctor. And he says, well, you have to talk to human resources, you've been terminated, and whatnot. And I thought it was an interesting case, so I talked to Hayden a little bit about it. Should the employer have known that the applicant was going to bring a workers' compensation claim? It's a tough one, right? Because he has bruises on him, he has scrapes on him. And at the same time, when they asked him, are you okay? He said, yeah, and he was ready to go to lunch. I'm really happy that it didn't go to trial. We found out that the applicant actually filed it a month late. So the 132A, we'll talk about it later, of how the statute of limitations is an absolute bar and will take away the jurisdiction of the court. And I think that's also important. What's also important about the 132A claim, and most people don't know until you go back and read it, is that there's actually an element to it where not only would the employer be liable, but the insurance company could be liable as well. So if the insurance company tells an employer and says, look, you need to fire this applicant, right? Or your premium's going to go up. That's another 132A violation. If you let them know you're going to cancel their policy or their premiums are going to go up, if they don't get rid of one particular person, the insurance company is now also liable for a 132A. So it doesn't just affect employers, it affects insurance companies too. Once again, that's not a fact pattern I've seen yet, but I could see it happening. I could see it certainly happening. All right, let's keep going.
Most of the fact patterns that I've seen that in my research and in my actual handling of cases is not the quote unquote discrimination because they filed a claim or because they should have known that they were filing the claim. It's most of the time we're in the midst of the claim and it's the return to work issue. That's where I see the most 132As come up, where there are issues with return to work. Who do you follow to have that person return to work? The process, that's a lot of the nitty gritty that I get it down into.
We're going to talk, because I have a couple cases that involve that exact situation. Let's go forward with the slide. So what acts constitute? Well, we discussed it. If you discriminate against by terminating an applicant as a result of filing or making an intent known to file, that's a 132A violation, but there are also actions that will give liability to a 132A. A reduction in pay or status. Obviously, any loss of seniority. Hayden and I have a lot of cases where the applicant is a merchandise clerk and would have been a supervisor by the time the case rolls around a couple of years later. And that is certainly an issue. So if somebody would have had a $2 an hour raise and they don't get it or they don't get the promotion, that's also one of the acts that will rise to a 132A violation. That also is the same with the loss of promotion, same thing, loss of a pay increase. These are the interesting ones. Thank you, Hayden. The transfers of workplace or refusals of transfer. And I have two cases right now on those issues. So I have right now a awesome receptionist who did a great job for a medical building, for a medical facility. And they promote her as the receptionist to a secretary in the radiology department. She's making a lot more money. She's done everything in her power to make this a good place to work. She's brought in pictures. She's brought in plants. She's actually put some of her own money out and bought merchandise and postcards, all to make the radiology department look nicer. She has a slip and fall. She has numerous injuries, and she needs to be modified. So the employer says, okay, we'll modify you. And they put her upstairs where she's at a desk doing nothing, and she's all by herself all day long. So the applicant does that for a couple of days. And then the applicant says, this is a constructive termination. I can't work like this. And you guys have discriminated against me. Well, I talked to the employer, and this is the only place in the entire medical building where there's not a lot of activity. There's nowhere else to put this applicant to have those work restrictions accommodated. So the question becomes, is it a 132A to make this applicant transfer to upstairs where she's all by herself? And I don't know the answer to that. You know, it's going to play out, but it's a good one, and it's something that we have to be somewhat sensitive about. What are your initial thoughts on that one, Haven?
Well, I mean, the problem is that you're accommodating a restriction that this applicant is looking for, but at the same time, that applicant is being singled out. So it's a catch-22. It's definitely, it's going to weigh the scales of what is seen as the discrimination there.
That's right, and I think they're all going to be very factually significant. They're going to run on facts, but these are the creative arguments that applicants' attorneys are going to make.
So we had a question come in. Just okay. Sorry to stop you, but we had a question come in. Can the attorney who is handling the workers' comp claim also handle the 132A claim?
Oh, they're a couple pages ahead of us. They can in certain circumstances. I promise you we're going to get there. When we have a lot of self-insured employers, big employers, and we have a lot of clients like that, where the money's the same. And in those types of situations, I don't really see a conflict of interest. And if the employer wants us to do it, we'll do it. But I think in any other situation, there may be a conflict of interest. And I think we're going to talk about that. And I think I'm going to go with Hayden on this one and say, try not to. Try not to do this. If you have to, get a very strong conflict of interest. But I would still advise that they get their own point, their own. You could have Bradford and Barthel do it. They can put up the proverbial wall between attorneys where nobody can review each other's file, and that will work with the conflict of waiver. So it just depends on the situation, how comfortable the attorney and the managing attorney are with the factual situation. Great question.
Because if I remember correctly, Glenn, that did happen in our office before, where somebody in our office, I think it was you that was handling the 132A claim, and someone else in the office was handling the workers' comp, completely Chinese wall. There was no looking at each other's file, nothing like that with the conflict waivers.
Yes, it happened with one of our associates in Woodland Hills, and he did a great job. He actually had the 132A portion. And so we actually, and we'll talk about this as well, we were very cooperative with each other as far as, you know, the evidence is concerned that would assist our cases, but at the same time, not getting into any of the privilege documents. So you have to be very careful as well. Refusal of original job position. You know what? I get a lot of psychiatric claims where the psych report says there's no real work restrictions other than the applicant shouldn't work with Fred. And if the applicant has to work with Fred, she's temporary partially disabled. So, or temporary totally disabled. So then it becomes a problem for our employers. So the employer has Fred, he's a great supervisor, he's never had any problems before. And there's an allegation out there. So you're not going to get rid of Fred, so what do? And we will advise the employer based on each situation. It's once again, it's very fact specific. And it also depends what Fred has in his history. Does he have a significant history of prior complaints by his workers? If he doesn't, and you want the facts to come out, and that's what the employer wants, and you refuse to modify, at least you know that the 132A potential is out, because it is a very sticky situation. And I'd rather them talk to an employment attorney than us when it comes down to that. We'll, basically, try to side and err on caution and say, move this person away from Fred, anything you can. Just try to get them away from Fred. And that way you don't have the discrimination and you don't have ongoing temporary disability. So I have a couple of cases where applicant can't work with Fred. So in one situation, the employer says, well, Fred's too important to me, and they're paying temporary disability. And I have another case in which they're refusing to modify, saying Fred didn't do anything wrong. I will take the position of the employer in that. And that's what we do, we fight. Next slide. This is what I was telling you earlier, just really quickly. It's another provision that's in the labor code that we usually gloss over. We don't see it too often. But if somebody's going to testify for the applicant and you believe that this person is going to testify, or that person says they're going to testify, any action that you take against that witness is going to be a 132A violation. So be careful. Leave the witnesses alone. I had the situation come up once in 25 years, and the person actually did get 132A benefits because he was threatened not to testify. And if you do testify, you're going to lose your job. That's enough. That's a violation. So just know that it's out there. They have the exact same remedies as the applicant at a 132A. Next slide. We talked about, I'm sorry, we can go back. I'm sorry. We go back one. We talked about it being a misdemeanor. It's never happened before. We don't want it to happen, so we're going to try to avoid it. So that's the consequences as far as the penal code, but there are other consequences to a 132A violation. I have a lot of attorneys that have talked to me over the years and said, big deal. You know, even if we have to increase the exposure 1/2, it's capped at $10,000. It's no big deal. Big deal. We'll pay $10,000. We'll pay $250 in cost and expenses. Well, I don't want to be the one to tell the employer that you got to pitch in $10,000. I don't know if you've dealt with these employers before, but whether they have 1,000 employees or whether they have 20 employees, nobody wants to pay out that $10,000. So the $10,000 is still significant. Think of it as being significant to any employer you have. They're not insured for it. It's coming out of their pocket, and they're upset when they have to pay for it. So, you know, you're going to have to be diligent. So if it's not the $10,000 and it's not the $250, that's a big deal. Then what is the big deal? Hayden, what is it?
It's that reinstatement, reimbursement for lost wages and benefits.
That's what I call the whole enchilada, right?
Yep.
So if the $10,000 is a taco, B3 is the whole enchilada. And what are we talking about here? Well, we're talking about, by the time we usually get these cases, a couple of years rolls around and the applicant's been off work, and now the applicant is entitled to reinstatement, which means if the applicant would have been a supervisor, that extra pay is going to come into consideration. You have to put him back on his job. And then reimbursement for lost wages. Is there a $10,000 cap on that, Hayden?
Nope.
No, there's no cap, guys. This is really important because, like I said, we get these files a couple of years down the road. Applicant's making $100,000 a year, right? This applicant is now potentially entitled to $200,000. So your employer is saying, wait, what happened to the $10,000 cap? Well, this is B3. You're in a whole enchilada situation, right? So it's extremely important. There's a lot of money on the line. And
by the way, employer, after you pay out that $200,000, you got to take this person back.
Right? And promote them. Okay? This is, you know, it's crazy consequences. And that's also what makes 132A so dangerous. So when people tell you it's no big deal, it's 10,000 cap, that's not true. It is a big deal. And it's not the $10,000 cap that is going to keep us from sleeping at night. It's B3. So we need to focus our attention on doing whatever we can to defeat a claim that has a B3 element to it. The issue that I had years ago was I had an examiner say, actually it was an employer who said, who cares, right? The insurance company paid TTD for 2 years. Well, guess what? That's a partial payment, right? Because temporary total disability is 2/3 of a salary and it's capped. So we're talking about potentially thousands of dollars more because now the only credit you get is what the insurance company paid for temporary disability, or 2/3 of the salary up to a certain. So yeah, you might get a credit, but it brings upon another issue. Who pays the money, right? So if I'm the insurance company's attorney, on the main case in chief, I'm going to say, wait a second, had you not terminated this person unfairly, we wouldn't have to pay temporary disability. So the 104 weeks of temporary disability that we paid equates to $80,000, and we want reimbursement of that $80,000 from the employer. So the insurance companies, it's a little trick they usually don't know about. I don't know how understanding the attorneys are about this, but it's part of the ongoing kind of conflict of interest between the employer and the insurance company that's going on. So when I hear the question, should a main case in chief attorney also handle the 132A claim? It depends. If I'm going to be a very diligent case in chief attorney, I'm going to say no. I think it should be a different.
Well, I think that's a clear case of conflict right there, and that's a clear thing that can happen, which is why there has to be these strict conflict waivers.
Exactly, and that's what it brought me back to. I think we went full circle on that question. So just just be very sensitive to that, guys. So we're talking about a whole enchilada case. All right, next slide.
Well, and before we go off the whole enchilada, it brings to my mind that Scagliotti case that we were talking about, where, if I remember the facts correctly, the applicant was actually terminated from employment back in 2014, was off of work for about 16 months looking for a job and didn't have any income, then found a subsequent job, was working that job, laid off because the pandemic started, and then was out of benefits after that time. The 132A claim resolved with the finding and award that the applicant gets the 16 months of benefits, or 16 months of lost time off of work when that applicant was terminated and couldn't find a job, then gets reinstatement to the original job whenever they're allowed to go back to work because of the pandemic, and is not penalized on the time that they have been off due to the pandemic because they didn't get EDD benefits because they were technically unemployed. He gets those wages that he lost at that time, all from the original employer.
We talked about this case. We hate this case. And one of the things about this case that I brought out, would it have helped if the employer had a policy? And we're going to talk a little bit about that too, is when these employers have policies of what they do and what they don't do when it comes to work restrictions, when it comes to terminations, it always looks better, than an employer who doesn't have a policy. We're going to talk about that as well. But I thought that was a very interesting case, and I hate that.
Oh yeah.
And we're going to see, what the appellate level and what further courts do about it and how it gets. So we're back on the whole enchilada. We know that it could be years. If you're an insurance company that's listening today, get us the file as soon as possible. If you're an employer that's listening today, get us the file as soon as possible, because it's ticking. It does not stop. There's no 104-week cap. This could, in one situation that I took over back in the late 1990s, I took over a file that had 10 years of retroactive payments on a site claim, and somebody that was terminated. 10 years, and at that time it was $50,000 a year, is a lot of money, and it was a $500,000 potential. So I would say you have to make sure to do this timely. And something else that Hayden and I talked about is, when do you start? Do you start when you see an application that checks off the 132A form, or do you start when you get a petition for 132A benefits? And Hayden and I are thinking more and more, you should start as soon as possible. So at the deposition, if you're the case and chief attorney, you're going to get a better understanding as to whether or not there really is a 132A or an S&W claim. And if it's just merely checked up on the petition, on the application, you may not have to do any further discovery, but we'll talk about that. But it's scary because a lot of the applicants' attorneys will say, look, there's no statute of limitations argument because we checked it off on our application and that was there for a year ago. So we'll play around with that a little bit. I think you have to protect yourself. And I think even when you're filling out a compromise and release, and they put not filed, that will help because they're admitting that they never filed it. But if they refuse to put that there or they don't put that there, I think you have to put down as per the application if it's checked off. I would put some type of specific detail on the actual application because the application checked just so you're 100% clean when you do a compromise release as well. Mitigation. So I have this is also early 2000s before Navarro came out. So one of the discriminations actions obviously would be to eliminate healthcare. So, okay, you're no longer working for us, we're going to stop your healthcare. Well, in my situation that I had, we had an applicant that had their healthcare terminated before Navarro, and I'll tell you why that's important later. And when their healthcare terminated, the applicant had an emergency. Shortly after they terminated his insurance, there was a non-industrial motor vehicle accident. He's rushed to UCLA emergency, and they end up spending about $120,000 to $125,000. And the applicant is billed for every penny of that. He doesn't have any insurance because the employer actually canceled it as part of the termination. So the question becomes, are we liable for that $120,000 because we unlawfully stopped the applicant's benefits? What do you think, Hayden?
Well, I mean, you unlawfully stopped them, and they're entitled to all the benefits that they would have received, but for that. So
there's a reason why Hayden says "but for," because the last time we did this presentation, I wanted to let everybody realize that when we took torts in our first year of law school, we were given a fact pattern, right? Betty is driving and she hits a cat and kills the cat. John was driving behind Betty and couldn't stop in time and rear ends Betty. Okay, Arthur couldn't stop in time and rear ends, and it keeps going on. Well, as it turns out, the one in the middle of all of these crashes was not able to make it to the factory where he works in time to turn off the gas, and there was a gas explosion. Okay, the people injured in the gas explosion, they want to sue everybody. Okay, they want Betty, they want John, they want Jack. There's a law in torts, and it's called proximate cause. And you'll say, but for Betty running over this cat, the explosion would have never occurred. Yes, but we need something to rein in the liability, right? So now we have proximate cause. So when Hayden and I were initially talking about this case, we looked at each other and said, but for us not canceling, there wouldn't be a $120,000 charge. And then we thought about it a little bit. And we said, you know what, like proximate cause, it has to be foreseeable. It has to be reasonable, right? Well, that's what I argued. And pre-Navarro, these cases were going forward and defense was losing. And I made the argument. I said, wait a second. There's a duty to mitigate, right? I said, if this applicant would have purchased COBRA benefits for the 2 months that he didn't have any health benefits, he was offered COBRA, and he said no. It was $800 a month for 2 months. It would have cost him $1,600 to avoid this $125,000 charge. Well, they didn't agree with me at the trial level, so I brought it up on recon, and they said, yes, Mr. Young, you're right. There has to be mitigation. And the applicant did not mitigate by getting COBRA. And we ended up paying $1,600 instead of $120,000. But, once again, mitigation is very important, and especially in these types of cases. We want to prove, and when we look at mitigation, we want to prove that the applicant was able, willing, and ready to work. So how do we do that? Well, I usually get the EDD records. I get unemployment records as well. I want the unemployment EDD records. Why? Because what is the applicant certifying when the applicant is getting unemployment? They're certifying that they can do their usual and customary duties and that they're actively looking for work. Well, if that's the case, then on the, maybe if the applicant is actively looking for work, but what I'm finding when I'm submitting these records, I'm seeing breaks, right? So I see that the applicant had unemployment from January 2021 to April 2020. Then it stops. And then I have nothing, right, for 6 months, and then I see unemployment start again. So I think to myself, what really happened during this gap? Well, the applicant was ready, willing, and able, and then the applicant gets terminated for cause, right? Is that our fault? Is that our fault that the applicant got terminated for? The applicant would have continued working. And if he's ready, willing, and able, and he wouldn't have been terminated. So obviously that's going to be mitigation. And the amount that this applicant could have made if he hadn't been terminated will be the dollar for dollar exchange on what we may owe for that period of time where the applicant was not working. So is he ready, willing, and able? I always argue, look at the unemployment records, look at the disability records. A lot of times you will have a work restriction that would have been modified had the applicant not been terminated. So we see this a lot in our temporary disability trials. We see them in these as well. It's very important. The applicant, if you hadn't been terminated for a cause, we would have been able to modify. All right, so what's our strategy on an enchilada case? We're going to have to work our tails off, really, right? We're going to have to take depots. We're going to have to talk to witnesses. But what if you're not convinced it's an enchilada case? What if the applicant's working for a subsequent employer and there's no issue of retroactive benefits, right? My advice always, lay low, okay? Most of these cases will go away, like a miracle. But no, they really will. They'll go away. 99% of them will go away without you doing anything on the file, right? The only thing that I would do, in some cases, I call the main case and chief attorney and I say, look, if they don't agree to bifurcate the deposition, then I'll come and I'll show up, right? But I try to get them to get the applicant's attorney to bifurcate. I don't want to even have to explain 3 hours of attendance in the deposition to my employer when I show them my bill. Because why am I at that deposition, especially if they could have bifurcated, right? So if it's something that can be bifurcated, you want to work with your case and chief attorney. You're going to cooperate with them. They're going to cooperate with you. And it's also going to be, very important. If they settle at that deposition, they'll know to have the 132A claim dismissed without prejudice. So at the deposition, you don't have to show. They dismiss the claim. You keep all of your expenses down, and the case goes away. And that's how most of my cases that I resolve as a case in chief, if there's a 132A claim, I get the dismissal on it on behalf of my co-counsel, whether they've been assigned or not. Will applicants' attorneys give you a problem dismissing? No, they don't care. They'll dismiss the claim. I haven't had one applicant's attorney tell me, no, I'm not dismissing prejudice. Although when I say lay low, I mean it. I did have a co-defendant in a lot of cases who did nothing but 132As for an energy company, and I did the case in chiefs. And this co-defendant would show up with gold chains, 3-piece suit with a vest, right? And he had to ask 100 questions about the 132A claim, right? He's billing his client. He wants to put on a show. And I had a couple of cases where the applicant's attorney I dealt with on a constant basis on this case said, look, to be honest with you, I wasn't really going to argue 132A. I wasn't going to do anything on it, and I still want to settle for you for $20,000. But that jerk over there, he's pitching in $5,000, right? This guy that just hammered the applicant for no reason on a case that would have resolved without any 132A questioning got involved. So my advice, don't wear a 3-piece. Don't be too active unless you're sure that you're in that enchilada. And that brings me to keep your expenses down. I don't like litigation bills. We used to do all of our witness statements in person, and I thought there was a great benefit to be able to see their reactions, to see how they speak and how they will be at trial. Now we do everything over teleconference and we make the best of it. But for the employers that allow it, we would love to meet you guys in person. Personnel file, very important. I think I emphasized this at the last time we did a 132A seminar. But I said, go to your client and tell them you've lost if you don't have a personnel file. Well, it's not that bad, but yeah, that's the crux. It's the bloodline of what we do. We need that personnel file. Get it as soon as possible. If you're the employer, give it as soon as possible. So back to depositions, yes, bifurcate if you can. If you can't bifurcate and they won't dismiss or bifurcate it, you better show up. You better be ready to show up and you better be prepared. If you're showing up at a case in chief deposition, don't wait for your own deposition. You may not get that chance. You have to show up. You have to be prepared. Be the smartest guy in the room. And as I always tell attorneys, if you're not the smartest guy in the room, be the best prepared for any deposition or any cross-examination.
Well, to Glenn's point, if you're walking into the deposition to do a 132A and you do not have the personnel file, you have lost. You have to have the personnel file. Absolutely.
Well, thank you. And I thought I overemphasized it last time.
Nope, I'm going to emphasize it even more, because that really is the crux of it. Is when we get to it later, you're going to see that a lot of these 132A claims will fall on whether it was documented or not. And if it's not documented, you're going to be in big trouble. If you have documentation, which should be in the personnel file, of all of the different write-ups or the different actions that have been taken, you will have a very good defense. It will, you'll still have a 132A claim most likely, but you will have the defense and they will not be able to succeed.
And I have a new employer that we just got as a client, and they refuse to absolutely let me interview any of their witnesses. They refuse. You cannot talk to my witnesses to my employees. Okay, that's fine. They got me witness statements. So I use these witness statements to impeach the applicant, to show applicant's attorney, look, we know what we're doing over here. And there's nothing really to this 132A claim, even though, and obviously, you won't have these witnesses at trial, but what you will have is applicant's attorney believing you have a bunch of witnesses at trial. So, it will scare them off as well. And also, yeah, so on 132As, you're going to want as many impeachable type of witnesses and evidence that you can get. If you can't get to the witnesses themselves, at least give us a witness statement, guys. Give us something to work with. We need all the assistance we can get this dismissed, or to get a very small, if not nuisance value, out of it at a settlement. Focus on business necessity. It's very important. When I say be careful, COVID gives us a lot of defenses now as far as not being able to modify. We can't. We're not making any money anymore. No, if you have 10,000 employees and if they've not been affected by COVID, you're not going to really be using this defense. But most of us are, And so when they say, what's your best defense for 132A or work modification, I tell them, COVID, COVID, COVID. MRSA, right? COVID, that's your best defense. You've had to lay people off. You've had to close your factory. You had to close certain locations. We've had to make 10-person jobs, 3-person jobs. So now there's no room for that applicant. That's business necessity. That will hopefully stave off a 132A. Statute of limitations are important, guys. The reason being, in the 1990s, when I took over a defense attorney's file, I was working for another firm. This defense attorney became a judge, and I took over his files. And he had about 2132A claims in his file. At least 7 of them were barred by the statute of limitations. They didn't file it within 1 year of the discriminatory act. So define the act, make sure it was filed within 1 year. Once again, we still have that issue now where they say, well, it was on the application. Well, sometimes that application was filed within 1 year from the discriminatory act as well. And on the flip side of that, the actual date can be extended. What if he's terminated in good faith, but then his health insurance is terminated 90 days later? Well, that wasn't the termination. It was the health insurance. That gives me, as an applicant's attorney, 90 more days to make that statute. So statute of limitations is important because it's jurisdiction. That's when you get to tell the time.
I think it's important to really focus in on the discriminatory act part to it too, because I hear a lot of employers will say, well, I haven't fired the applicant, or there hasn't been a termination. They filed their claim and everything. I haven't done anything to them. So there is no discriminatory act, or the discriminatory act has passed. It's been over a year. And then you start to get down into it, and this comes back to my issue of the return to work, which is then they start, you start bringing out a little bit more information of, well, I could bring them back here, but I didn't want to because I don't like them. There's your discriminatory act, and we're still a month removed from it. So that you're within that statute.
Well, that's a great point. You have to define the act and define the applicant's allegation, which act, and then always try to move that. Well, that wouldn't have happened if you weren't terminated, right? So termination was there. So we're always playing around with the dates in the actual act. That's very true. Next slide. Mitigation, more mitigation. These are the questions that we have, or that we look for. Are they requesting unemployment benefits? Are they really looking? Are they looking for work? Are they ready, willing, and able to look for work? Were there any work restrictions that they were looking for? A lot of times you'll have work restrictions, but they won't look for work with work restrictions. So they'll say, no, I can't do that type of work. And one of the classics that I had that happened just several months ago was I asked out that it wasn't a 132A depot. I was just trying to cut off liability for temporary disability. And I asked the applicant, I said, look, you're a 4-year graduate. Is there any reason why you couldn't try to get a job as a substitute teacher? And he looked at me and says, what a great idea. And the applicant's attorney didn't object. He says, what a great idea. I said, you could have done that over the last year and a half. He goes, I suppose I could have, yes. I said, thank you very much. And I kept going on with the deposition. You'd be surprised what these people will admit to. So always look into that. Look into what comparable to the applicant's employment or comparable to his training did they do without those work restrictions when you're dealing with a mitigation of either 132A or even temporary disability. Strategies of coordinate with your 132A counsel. Yes, it's symbiotic, guys. So they're going to give you witness statements sometimes. You're going to give them depositions sometimes. Share information. Okay? Do not hesitate to share information. Do not share anything attorney-client privilege, but go ahead and share information. I'm okay with that. Jurisdiction preemption, we'll go right on to Navarro. I'm going to let Hayden talk about some of the cases as quickly as he possibly can, but there's one thing I wanted to say about Navarro. Prior to Navarro, there was a 132A claim that was attached to every case we had. So in the late 1990s, early 2000s, those who were lucky enough, like me, to practice during that time, there was a 132A case on every single one. Why? Because when health insurance canceled, everybody would get a 132A. So it became interesting that it took Navarro to finally give us some help in this. And what Navarro says basically, if you're an employer and you're participating in the applicant's healthcare benefits, dental benefits, vision benefits, guess what? This is an ERISA issue. It's a federal issue. It's not handled by workers' compensation. And the 132A statute is completely inapplicable. And that means that we, as the Workers' Compensation Appeals Board, have no jurisdiction. So this is like one of those few chances where you can get to tell the judge, Judge, I love you, but you don't have jurisdiction here. This is a Navarro case. This is federally preempted. This became one of the biggest cases for defense, and it's still good law. And Hayden has a couple cases about Navarro, but it is still really good law. Know that, and know that a lot of the claims that used to be compensable are no longer when the employer is participating in that process. What else do we have? Union collective bargaining agreements, really quick. I used to work for a school district that after 6 months of no employment, the teacher or the person in the union would be terminated automatically. It didn't matter if it was a work contract. It didn't matter what it was, just everybody was treated similarly. That's not a 132A violation. If you're treated similarly or the same as you would from everybody else, then you're not discriminating. You have to kind of treat this person different because of it. So, you know, saying I'm fired and I'm only fired because I haven't been working for 6 months, That's right. And so would everybody else who didn't have a workers' compensation. All right, I'm going to go ahead and hand it over to Hayden for the last couple of minutes. Sorry, Hayden.
No, you did. We did great. So real quickly, again, I'm going to harp on the, do you feel lucky to terminate an applicant or an employee? You got to have the documentation for it. A lot of these cases fall on the documentation. There is the most recent case that I looked up as there is a Larea case versus Northrop Grumman. In this case, there was a finding of no 132A violation because the applicant had been written up before his injury for unexcused absences and different warnings. He then has the injury, at which time they wait for him to get back to work, and then they terminate him. There was a finding of no 132A because they had all of the documentation set up that they were getting ready to terminate the employee because of all of the unexcused absences, but for that, and I know there's that phrase again, but they had the injury. If that injury didn't occur, that person would have been gone. So they had the documentation present to show that once he came back from the injury, bye-bye. And they were able to do that. They were able to show that there was no 132A. But on different cases where there was a certain case that it's coming to my mind where they had the applicant back to work because the primary treating physician had found that the applicant could work full duties. AME 4 months later says, no, there's these work restrictions, and it's all of these different crazy work restrictions that the employer didn't know which way was up and which way was down. So they then took the applicant off of work to clarify the work restrictions with the AME. Applicant says, but my PTP says I can go back to work full duties, and I was working full duties for the last 4 months and not having any issues. You don't need to take me off of work. You shouldn't have taken me off of work. Here's the 132A claim. And in that case, it was found to be a 132A because the employer, and this goes back to one of the things that Glenn had said, you have to have policies in place. The employer did not have a policy in place of how to handle return to work when there is this conflict between AMEs and PTPs it was handled completely different than if it was a non-industrial injury. If it was a non-industrial, you have your primary care physician who says you can go back to work, you go back to work and you're perfectly fine. Primary care physician says you can't, you don't. In this case, there was this conflict. So this applicant could show that they were being discriminated against and they were being singled out because it would not have applied the same as it does across the board for industrially injured employees. And in that case, there was a
policy. What we talked about, if they had a policy again that they are only going to go by PTP restrictions, not penalty relief, and that was their policy, right or wrong, it doesn't matter. They had a policy in effect.
Correct.
And I think
and it would have been applied.
And it would have been applied. So that's huge. And who makes that policy? Workers' comp attorneys shouldn't be making that. That should be made by your labor lawyers and employment care.
Correct.
And this is the type of effect we have. Tammy, we didn't leave you much time, Tammy, but I know there were a couple of things you wanted to mention. If we can get you back on.
Yes, absolutely. There are a couple things I want to mention. First, Sean, can you guys hear me okay? Yeah, okay.
We can hear you.
Sean, you answered our intro question of how far do a typist's hands travel in a day with 12 miles, and I missed your correct answer, so I just wanted to give you a little shout out. So I sent you an email. I'm going to send you a little prize. And with that, I just want to thank you all so much for joining us today. We appreciate all of you and hope you enjoy the rest of your week and a nice long holiday weekend.